Hello and welcome back. It is 2:02. Get started. I would like to go back to agenda item 4A with our definitions and the section from 4825.1 C referring to the word client, and turn it over to Tara for her comments.
All right, during the break I located at least two statutes under the Veterinary Medicine Practice Act that use the term owner. 4827. Jessica, would you like to display the information I emailed so that we can all kind of take a look at what I'm reading from?
Actually, I'm going to ask Jeff to display. I'm not logged into the meeting, but if Jeff can share it on screen, he has it. So, Jeff, there was an email from Tara earlier. If you can share that email. She sent it at 1:45. There we go.
Okay, so both of these statutes, 4826.1 and 4827, use the term owner. And it seems to me that the board is not struggling with the definition of owner in either of these sections. The first one, 4826.1, is about removing liability of a veterinarian who is rendering emergency treatment to a sick or injured animal in the absence of the owner of that animal. (4827) is about an exemption from the practice of veterinary medicine when a bona fide owner is practicing veterinary medicine on their own animal. And it also goes on to the owner's bona fide employees and any person assisting the owner.
Jeff, can you blow up the language? Please make it a little bigger. Thank you.
So I've got two requests for the committee. One is to consider that the Practice Act contains the term owner in other statutes, and we don't seem to have any trouble defining what owner means under those sections, and therefore perhaps maintaining the proposed definition of client to mean the owner of the animal in the VCPR legislative proposal. And number two, the request is to consider whether or not we should add a non-liability provision in 4826.1. In the language you have before you, there's text that is underlined, and that's proposed to be added to the statute, and provide that a veterinarian shall not be liable in damages to the owner of an animal when the veterinarian relies on representations by an individual that the individual is the owner of the animal. That's to kind of button up this new definition of client so that the veterinarian is protected when they are presented with an animal for treatment, and the veterinarian doesn't have to track down written documentation that the person in front of them is the actual owner of the animal, but the veterinarian can rely on those representations of the individual to enter into a VCPR with the individual and provide treatment. So those are the requests. Number one, can we keep the definition of client to mean the owner of the animal? And two, do you want to add a non-liability provision?
Thank you, Tara. Comments on that from members of the committee?
So my understanding is that we would agendize 4826.1 at the next meeting and then add it if we want to move forward with that.
So I would say that if we get legislation introduced this session,
Right.
so then what happens at the following meetings is we would just agendize that whole legislation. And so if we want to add to that legislation, it would be agendized and talk about it there. We can request that it's added.
But the point would be to move forward with the current legislative proposal, get that introduced, and then potentially amend that bill at a later date.
And then my understanding is that the challenges with owner and that word really are not in this setting. It seems like it's more of a civil thing.
So quickly, I researched, and under the civil code, there's strict liability for dog bites. And so if a dog bites someone else, the owner of the animal is strictly liable for damages to the individual who was bitten. And that liability is the owner to the victim. For our purposes, we're trying to determine the owner just for purposes of creating a VCPR to treat an animal. And we're not looking to make the veterinarian responsible for getting, written confirmation that this person is the actual owner of the animal, which, may or may not exist depending upon what paper trail follows this animal. But to the extent there is a paper trail, that would be helpful and protects the owner in the event that someone else, like a horse trainer, purports to a veterinarian to either be the owner of the horse or the designated agent on behalf of the owner and is requesting the veterinarian provide treatment. In other scenarios, like small animal clinics, we recognize that there's so many situations where an animal is presented to a veterinarian for examination and treatment. And, again, we don't want to make veterinarians take the extra step of, receiving written documentation. But this provides the owner of the animal the ability to designate an agent on their behalf. And if there is no such designation, then the owner has some form of protection, but not to go after the veterinarian. And that's why I believe this additional piece for non-liability for relying on representations is important. But we're definitely trying to better define who the individuals are in each scenario. We've got the veterinarian, we've got the person who purports to own the animal or persons, and then other individuals who are standing in the place of the owners and creating that relationship with the veterinarian and consenting to treatment.
Thank you. Do we have any public comment on this from those in the room? Connie, thank you.
It's green anyway, so it just confuses me. I understand this is a difficult issue, but I guess what I would say is one thing, these are older statutes, and owner is never defined in the Practice Act. So we are defining client as owner, but even though owner appears in other statutes, it's never defined. And I only brought up the strict liability thing because it has nothing to do with that. I understand that. It's not related. But I deal with this all the time in the administrative cases that I do because it's very difficult to determine who called the shots, who was the owner. So, I still think that just because we've used the term owner in older statutes, it's never been defined, so it doesn't really give us any assistance to how we define it in this new, very important, very different statute that you're proposing. So I still think that you'd be better off just calling it a client and leaving it at that and trying to stay away from the word owner, because the owner used in these two statutes is not really a problem like it could be in this new one. Thank you.
Good afternoon, everyone. Dan Baxter with the CVMA. I agree with Ms. Lutz. I think the other thing, especially after listening to the conversation, I asked myself, is the inclusion of an additional definition at all, again, with the benefit of this conversation, even useful? Is it actually helpful to the people that are going to be, reading and relying on this text? And I think at the end of the day, I'm, at least to myself, answering no to that question. This framework is dealing with the veterinary client-patient relationship, and client is a term that through custom and usage I think is well understood. And I think to go the extra step of defining client as something else, and as Dr. Miller put it, in this case a noun for a noun in its original format, I think is unnecessary. And while I very much appreciate the efforts over the lunch break to put more meat on the bone, I think I just keep coming back to the same result, which I don't think it's going to be a net benefit to those who are going to be reviewing this, and I think it could actually create additional confusion. So I agree with Ms. Lutz that I think the whole provision should just be left by the side of the road. I don't think you need it. Thanks.
Mr. Baxter, did you have any comment on whether or not a non-liability provision would be helpful?
I think you would either do both or do neither, in my opinion. If you were going to just jettison the language altogether, that is the definition of client, I don't think you need a liability protection of the type that was discussed. If you are going to add that provision and then essentially put in the language the same or similar as what you were suggesting, Ms. Welch, then I agree that a liability provision would be well taken.
So I guess my question is, in the VCPR, who is the client?
Again, I think I would say, and I'm obviously not a clinician here, but as I understand it, the word client is well understood. I believe it's used at other points within the Practice Act, and I think, again, just through custom and usage, it's something that everybody sort of intuitively understands. I do agree with the sentiment, although I will say I don't think we should put it in the definition section, but I do agree generally with the sentiment that Dr. Miller espoused, which is when you actually get to the subdivision dealing with all of what we are functionally trying to do, there is more definition, more substance to, in fact, let me grab the subdivision.
Well, I guess my point, and you may want to address it more specifically, when I look at the term VCPR, my first thought is the client is the owner of the animal.
Sure, but do you really need to put that and make it explicit in the Act when the term owner is sort of as fraught as we've been discussing here today?
Well, if we want to define agent, then I would say yes. I mean, that's the reason we're trying to put it in there, because it has to do with defining the agent who is now working in the space of the client who is ultimately the owner of the animal.
Sure, and here it says the client has authorized the veterinarian to assume responsibility. This is the subdivision I was trying to find, so it's 4826.01A1, and it puts some additional sort of texture as to what client might mean. The client has authorized the veterinarian to assume responsibility for medical judgments regarding the health of the animal. And then later on, obviously, that authorization can rest within an agency relationship, and an agent can do that. I guess I just keep coming back to what is the utility of actually defining client in the statute, proposed statute, when I think the people in the room have an understanding as to what the client is. So does it add anything? Does it help anything? Does it clarify anything? I don't think it does.
I mean, I think that we are all here because there was some ambiguity to what a veterinary patient-client relationship or client-patient relationship is, and the definition of that, and whether that was established in certain cases in a racetrack setting, which could also be in some of the equine settings. And I mean, I think that's really why how we got here, is because there was some ambiguity there. And so I think the whole purpose was to try and clarify that so that we didn't have this concern later and people that weren't being, there weren't, disciplinary actions against people for this problem, because now there's some clear definitions. So I think, that's the purpose.
Sure.
And so my concern about removing it is that we really haven't moved forward in that, and we still would have a gray area. I know that's the part that you found there and just read, I think clarifies it a little bit and is better than where we were coming into this, but I still am concerned that we aren't moving things forward, except for adding the definition for herd and some of the other parts of it are definitely all addressing other issues, but that specific issue that came up, it would still be there.
I agree. I would say just quickly that if the client is just anyone who creates the relationship, then that could be the trainer or agent. That there's no special designation or reason to have agent, because the trainer could be the person establishing the VCPR. Client otherwise means anybody who authorizes the veterinarian to examine, diagnose, and treat.
Well, what I was going to say in response to Dr. Bradbury is I think that in terms of not providing enough clarity and maybe not getting to the place where we want to be, is that I think the agency language that is contemplated to be added actually gets us pretty exactly where we need to be. I mean, as I see it, that's the real engine to everything that's happening here.
So what you were saying is when I had mentioned adding owner or owners or designated agents, that would be a more, is that what you're mentioning there?
Well, I guess what I'm saying is I wouldn't be violently opposed to that, but trying to kind of the Occam's razor, let's keep it as simple as we can. I think that with the introduction of the agency language, I don't think you need, and with the additional point that the word client is, I think, a known quantity. I think it's an understood term. I think it's a term of art in this context, and I think it's pretty well established. I think simply using that verbiage and then creating the agency provision, which again is really the driving force of the additional sort of authorization that this framework will allow, I think that gets us, the royal we, to where we need to be. I don't think you need the additional definition.
One comment and then one question. To get back to the action item of who this client is or what they're doing to be the client, if they're the person who presents the animal for care and with whom the veterinarian communicates to establish the VCPR, if that could be the definition, you can still have a definition of an agent. The agent is just the person who can assume that role, whatever that action is that they're doing. So I think there's an opportunity to define that with client, if you'd like, and leave agent as a subsequent definition, just saying that they can be substituted in for that.
I think, to to add on to what Tara was saying, if you do that, you don't even need agent, because the trainer in that scenario would just be the client, from what you're saying.
The trainer is presenting the animal. It's the same.
I understand. Yeah, I think that there is a difference, though, between a legal presentation and a physical presentation of the animal. So I'm bringing this animal in front of you.
Mm-hmm.
That's physical. But legally, somebody is procuring your services. That should be at the direction of the client, which in some cases is the owner. And this is herein where the problem lies. So Dr. Sullivan had mentioned, you know, when I think of the client, I think of the owner. And that is precisely the challenge that we have with our entire Practice Act, is that this board, and in the entirety of its existence, the MDC has been composed of primarily small animal practitioners. And so the world that we all think in is the one in which we have practiced. The fact is, in the equine world, it just isn't that clean and clear. So I appreciate you making that sentiment that, you know, client and owner are a synonymous term, but it's not the same in all facets of practice, and that's why I think we do need to put some more effort and thought into how this will go.
I agree with that, but the exception you're looking at, I think, needs the client statement of this being the owner, so that then the client can delegate the agent to represent them. Because that's, you know, that's really where we started. How do we get agent into this so that they can have,
right,
take the responsibility of being that owner away from home, you know?
Right. Well, so it just comes down to the provision of, you have a client, it's a person that does the following actions, and our law allows for that client to authorize an agent to act on their behalf. We are similarly doing that with RVT language by allowing an RVT to act as an agent of the veterinarian for certain purposes. So we just did that on the other side. It just has to be stated in the law, and the limitations of it have to be stated in the law. So I think it's possible, but setting that aside, question, is it possible to achieve the goal of consumer protection that the board is after by changing record-keeping regulations downstream, so that if you are in a situation in which you have like an equine type situation where the veterinarian is there at the barn and the trainer has 10 horses that all have different origins, can we provide some kind of requirement in the records for the veterinarian to obtain documentation to show authorization of this trainer to do that work, to procure the work from the veterinarian, or some agreement that the trainer has with the horse owner to allow, you know, them to make decisions about the veterinary care? Would that satisfy your goal of consumer protection in that regard?
No, because we're back to who's creating a relationship with the veterinarian. And if it's just anybody who's presenting the animal and then consents to the veterinarian performing something on the animal, that could be anyone. You don't need any legal authority to do that.
Mm-hmm.
So I think that medical record keeping, by keeping in your records who's been designated as the agent, is helpful to the veterinarian when the owners come to the veterinarian and say, oh my God, I didn't authorize that. That way you know, okay, well, I have this document, this is what I was relying on. But from step one, creating the relationship, if it's anybody who's presenting the animal, then it's anybody. It's not an owner, it's not anyone with a legal interest in the animal, it's just anyone who, you know, hey, veterinarian, come look at this animal.
Right.
So, you know, how do we get to establishing that legal interest in the animal such that consumers are protected, and then those consumers can designate their agency to someone else?
And doesn't this, I mean, it gets us there because it allows for that process to happen and for veterinarians to still be able to go out and deal with the designated agents, if the client is defined as an owner. I mean, I think that we still are able, that still gets as to where, equine practitioners are able to work with the trainers and the people at the barn directly, even though client is defined as the owner, because the owner's then designating it. So doesn't this language get us there?
Well, we've certainly taken a look at it, and I always defer to the attorneys, and I think Bonnie and Dan and all the attorneys in the room are the ones that really are best to answer the question, in my opinion. When I approach this, I always look at if it looks like a duck and it walks like a duck. So what is happening in the real world? And that's what I try to embody reflect in the law, because essentially that's what the law is. It reflects the will of the people. And so I'm trying to look at it from an action standpoint, like what role does this client play in this VCPR? So that's where I'm coming from with it, but I do understand the structure that you've set forth here to try to accommodate downstream, this unique facet of some practice types where you don't always have that owner of the animal present. And that's, for me, it's honestly not always have is actually the wrong term. I rarely have the owner of the animal present when I'm doing my job. And that's just the way it is for all equine practitioners. It's just how it works.
So I have a question, because I get the concern of, well, who legally is the owner, but what if we just made it to the client means the individual who represented to be the owner or presented as the owner of the animal? That way it at least tells the veterinarian, I'm the one who says I'm the owner. We put in the liability language that if they identify themselves as the owner, that's on them. But also, I think majority of the time, if you ask a trainer, are you the owner, they're going to say no, they're not the owner, so they wouldn't identify as the client. And then you have the agent. So if you just say the individual who identified as the owner, you take all the onus off of the veterinarian to have to prove that. You just have to say, this person said they're the owner, they're the owner.
Possibly. Could you also say that they identify themselves as having the legal authority or having possessive authority of the animal to authorize the care and treatment?
Well, that's the trainer again. The trainer possesses the animal at the barn. Where's the owner?
Right. Yeah. So I think what it comes down to really is this concept of the due diligence at the barn, where when I show up there, I'm going to assume that that trainer has the authority to procure my services for whatever they're looking for me to do. If it's vaccinating, so be it. And my obligation and role as the veterinarian is satisfied simply by me communicating with the trainer. I don't have to go forward and say, well, who really owns the animal and what did they have to say about it? Right now, we don't have to do that, but that's where we'd like to try to get to, it sounds like. So if there was some way to obtain that documentation or mandate that documentation, that might be something we could explore later on.
My concern is the documentation happens after the fact, and we're talking about establishing up front. So you have the act of establishing the VCPR and then document it later. And if you just do documenting later, it's not really saying who's authorized to establish that to begin with.
Yeah, it's a challenge. It really is. I mean, it can go either way. And, I mean, ultimately, that's why we have the board, right? So I appreciate your dialogue.
Well, I think if we have, if this goes through and there is some regulation that has a documentation component to it, I think, it would be kind of similar to the RVT thing. Doctors would be like just saying to the trainers, hey, what we're going to need to get from you from here on out is, when you take on a horse, you need to get this form signed for me, and
yeah, or in the absence of the form, I would need to talk to the owner,
right, and just
specifically,
yeah,
and I hope that's possible to do.
Yeah, and I mean, there's some provisions in there for emergency situations where if you weren't able to, you'd be covered, but I think it might improve, things for you guys in some way.
More often than not, the emergency situations are a good point, but that's not really as much as it is that the owners are in other countries, or they speak other languages, and I just don't, it's like you really have to run everything through the trainer. But that might be a discussion downstream, but it doesn't still solve the issue at hand today with.
Yeah, Dr. Miller, as I read this subsection C, for purposes paragraph 1 and 3 of subsection A, the client may authorize an agent to act on the client's behalf. What's the definition of client there?
The client is the person who's authorized the veterinarian to assume responsibility for medical judgments regarding the health of the animal. So
doesn't that then not protect the owner?
It doesn't go far enough, and that's what Tara mentioned. It's not possessive. So
not the person who's authorizing, because this is, if there's no owner, they don't have to, like the trainer can be the person authorizing, can establish the VCPR.
You are totally,
no agent necessary.
You are totally correct, but as this is written in context of what the client does. It's the action. It's not the noun. The action involved in this is the authorization. But your point was a good one, which is it's not simply the authorization. It's who really has possession of this animal. Anyone can walk and be like, yeah, go ahead and vaccinate it. It's who is the person who has responsibility, like who owns this animal. That's
who has
really
authority to designate this to another.
Right.
And if we don't know who the client is as an owner or some other legal interest in the animal.
Right. So the supposition has always been that that the veterinarian can take it on face value, that the client is the person who presents the animal to you and whom with you communicate about the course of treatment that you recommend after you've examined the animal. That's their role in the VCPR. So that's the action. It's who they are. And I understand what you're saying now. You're saying, well, we need to make a provision for an agent per this equine caveat that we have. And so in order to do that, you have to separate the definition of the client from that of a client agent. So what I would like to see is, can you define the client as what they do and then mention that they could designate an agent to do that in their place?
But the responsible entity here with what we're talking about is who owns the animal.
So we could say it's the person that owns the animal, and that would be what the person does.
Right, because otherwise there's nothing that, if the client is designating someone else to establish the VCPR, the someone else is taking all the action. They're presenting the animal, they're authorizing the veterinarian to do something. They're receiving communication from the veterinarian about the treatment plan. So in this scenario, the owner or person with legal interest in the animal is not taking any action. The agent is doing all the action in the VCPR. So what action could be the definition of owner other than owns?
Can I just ask, and this is not a rhetorical question, but maybe the answer would require a little bit of research. Obviously, the term veterinarian client-patient relationship has been in the regs for some time. Was there ever a discussion in the context of promulgating those regulations as to what client meant? Because if the issue of, well, what is exactly a client? How do we define the client? Was that discussion ever had back then? And if so, what was the answer, and what was the decision-making attendant to not specifically defining that word in the regulatory framework? Or was there a discussion? So I would be interested in kind of knowing that, because that could inform our discussion here today.
I believe we would not be able to find that information in the records. Okay. It's just too old.
Okay. Well, I mean, I guess
chiseled on a tablet.
I guess then what I would say is, at some point back in the day when the regulations were promulgated, there must have been enough comfort as to what the working definition of client was to not specifically define it. And I guess I would come back to, that was the case then, and really we're elevating this up into a statutory framework. Is there a keen and abiding need to define it now, if it's always been understood.
So a couple things with that. Tara's right, as far as it being so old, there was one point that the board was only retaining records on rulemaking for a very short period of time. So we would not even have that rulemaking package at this time. But also, I think when it was that old, especially the makeup of the board, and to Dr. Miller's point that most of them were all small animals who were writing it, they likely didn't even take into account that equine practice is going to be impacted as well.
Well, and that equine practice has become as divergent as it has, you know.
Yeah. So I doubt that it would actually contemplate this issue that's now risen this high because of the recent actions.
Dr. Sequoia has her hand up for a comment as well.
And Bonnie has a comment.
Thank you. This is Diane Sequoia. Looking at it from a slightly different viewpoint, who's paying the bill? So if whoever is accepting financial liability or is paying the bill, perhaps they should be considered the owner or as having a legal interest that entitles them to authorize care of the animal.
I would disagree with that.
Yeah, I disagree with that too, because oftentimes it's all over the map as far as who's paying. But I did like what Jessica, and I hope somebody got that down. I do agree with Dr. Miller that we need to define the client with some language that has a verb in it. And I liked actually what Jessica said, rather than just leaving it as owner, which raises a whole bunch of issues, to somehow define that client. And I hope somebody wrote it down because I didn't. But I thought I still am going back to some kind of language that defines the client as what they do or what they are, rather than the owner, because again, the owner is a nebulous term, and as far as payment, it's not always the owner that pays. And I don't know about equine, but I know with people who breed purebred dogs, it's not always the owner that pays. So.
Yeah. Well, I have situations in which animals are deposited in an estate, and there's a bank board of trustees that pay the bill, and that's a really messy way to go. But I have another concept that is half question and half comment, which is, to what extent does the board need to pursue consumer protection in this regard? So if you have a situation in which somebody takes their beloved horse and deposits it at a boarding stable with a trainer, to what extent do you have to allow that person their own responsibility of creating an agreement with that trainer for what the trainer can and cannot do with the horse? So when I show up to the barn and the trainer says, I need these things done to these animals, if the owner comes back to you, the veterinary medical board, and complains about something that I've done, isn't it plausible for you to say, well, look, that's an issue between you and that trainer. If you didn't want that program or didn't like what they did, you need to pursue them civilly for doing something to your animal that you didn't want. At what point do we stop here at this board in protecting the rights of individuals that may or may not? You may say that the trainer, who is the client, has just as many rights as the owner, who is absentee. So at what point do you say, well, look, you have to go to them. That was your arrangement or lack thereof with that trainer at that barn, and that's your problem with them. It's not the veterinarian's fault that they showed up at the barn and vaccinated everybody, and you didn't like that. So has there been discussion about that, or any? Are we winding ourselves up here in circles because really the answer doesn't lie with us? Is it something where it would have to be that consumer would have to find retribution or whatever they need through pursuing the trainer?
Yeah, if they have a contractual relationship, that needs to be spelled out in the contract, their contract.
So if it wasn't, or even if it was, is there ever a point where the board can say, look, it's not, you're coming to the wrong place? the veterinarian did not act inappropriately in establishing a VCPR because the client is this trainer who presented this horse to them. If you didn't want the trainer to be doing that with your animal, you should be taking that up with the trainer.
Isn't that what we're trying to do here by establishing a definition of client to preserve the owner's interests in the treatment of the animal and then allowing an agency situation so that the owner can delegate to the trainer the VCPR relationship, and if not, the owner can maintain the VCPR relationship with the veterinarian? I mean, that's exactly what we're trying to do, is delineate the responsibilities, owner, trainer, veterinarian, and, stop the mixing of the owner, trainer.
Client, yeah.
And I mean, I think that it would be different if we weren't here because of consumer complaints, but that's why we're here. And I mean, not as a board, yes, but I mean, we got to this place because of direct consumer complaints saying that they hadn't approved treatments and these things were done to their either precious beloved friends or huge investments that they've made, and these other consequences have happened. And so, I mean, I think there's if that wasn't the case, we wouldn't, maybe wouldn't be so concerned about it, but the reality is, that's what's happened. And so I think we're realizing it's a gray area. It's something that hasn't been addressed appropriately, and so that's what we're here to do.
Yeah, it's really, it's definitely a noodle baker because, this VCPR language is not our language. This has existed since who knows when across our entire country. Yeah. And it's interesting that only here and now are we, really trying to take up this idea of further defining this. So I really appreciate the dialogue and the discussion, and I think that it's more than warranted given the fact that we're going to be potentially pioneering a really dramatic change to how veterinary medicine is practiced in the United States of America based on this. And so I really think the dialogue is important, the research and the contemplation of what we're doing is important. I wish I had a better answer or a closer answer, but I certainly can't really come up with much else other than to say, could we define it as what it is? If it looks like a duck and walks like a duck, that's what it is. That's the best the closest I can get.
I have a question for Tara and Jessica. If we remove the definition of client, do we accomplish what we want to with the subsection C?
I don't think we do, because if we remove client, a definition of that, then client means anybody who's authorized the veterinarian to assume responsibility for medical judgments. That's step one. That could be anyone. That could be the trainer. Therefore, C, the client may authorize an agent to act on the client's behalf for purposes of authorizing the veterinarian to assume responsibility. There's no need for that. Because the client doesn't mean anybody.
So then I would think that if we define it the way we have it in C, and then there was a dispute at who was the owner, which I hear is a problem, to me that's a civil suit and not under our purview.
Yeah, what does that look like? If we leave in the definition of client to mean owner, what does that look like? The veterinarian is relying on somebody's representation that they're the owner of the animal, and they're the ones who created a VCPR and authorized treatment, or the owner, represented owner, assigns that responsibility to somebody else, and the agent creates the VCPR. Who's gonna sue? Other purported owners of the animal, could go after the veterinarian for, well, why did you rely on, Sally's representation that they were the owner when they're not? I own the animal. That's why, you know, we're trying to establish that there's some legal interest in the animal and the ability for that person to make judgments for their own animal. But, you know, if they can't be there, then they can assign that to somebody else. But this largely is going to be premised on what someone states to the veterinarian. Whether or not it's true, we're not trying to make the veterinarian responsible for tracking that down, but without establishing who is the client and giving them a legal interest in the animal, having any provision for agent in this VCPR, it fails.
And so that's why I recommended an individual who identifies or represents as the owner of the animal. That way, because right now the client means the owner of the animal, which is like matter of fact, but if you just say that an individual who represented or identifies as the owners of the animal, then you don't have to actually prove it. The veterinarian isn't held responsible for proving that. It's just what was told to them.
At the time.
Right.
Okay. So here's a scenario. So husband and wife. The wife has never brought the dog in to the practice. The wife works, her credit card's on file. The practice charges the credit card. That's incidental. It doesn't make any difference. The husband is the one who's always brought the dog in. And that's the person who the veterinarian knows, who has a relationship with, who's communicated about the condition of the animal. And the wife comes in and says, well, I'm the owner. I'm the owner. I, as a veterinarian, am going to say, I've never seen you in my life. I don't know who you are. And that doesn't amount to a hill of beans for me, because the person who I've worked with on this animal, who I've fulfilled the VCPR requirement, which is A1 and 3, is the man that I've been working with. He's my client.
Sure, but in that scenario, when you're working with the husband the whole time, wouldn't the husband being the one identifying themselves as the owner?
Yes.
That's what I'm saying. So in that, if we're saying the individual who presented or identified themselves as the owner, and you have that, then that's...
But there's going to be more than one person. She thinks she's the owner. The action, it's the action as to what they're doing.
So are you objecting to establishing a new VCPR with the wife? Because you already established a VCPR for this animal with the husband.
Well, how can you? I mean, if it's an ownership dispute where she wants the records and doesn't want him to have the records and wants you to stop treating the animal for basing what he says, if they're both telling you they're the owner, and I'm now obligated, based on their declaration that they're the owner, to call them my client, we're further down a rabbit hole. What you want to be able to do is say, look, my client is the person who's authorized the animal to be treated by me, and they're the person who has presented the animal to me. They may designate an agent to do that on their behalf, but they're the person who has legally said, I would like you, the veterinarian, to look at this animal, and I'd like to communicate with you a treatment plan.
But if there's somebody else acting as the agent, they could just present the animal and say, hey, veterinarian, I want you to treat. There's no legal authority.
But that's just somebody being dishonest. That's not the same as a trainer saying, look, I'm the trainer of this animal, which most veterinarians know that the trainer doesn't own the animal, right? We know that. We know that this animal is in training with them. So it's at least on the equine side, that is satisfied just by the nature of what practice is with that. But if somebody comes in and they're dishonest, you're never going to legislate to the lowest common denominator. You have to look at it where there's always going to be somebody who tries to circumvent the law, who finds a way around the law. But I think the laws reflect what's actually happening. The trouble with the declaration of you being an owner, that means 10 people come in and say, I'm the owner of the animal, and now I'm your client. And I've never seen him before in my life. The person I've worked with is the person who's brought the animal in all the time. And if that person says, hey, I'm going to have the dog walker bring the dog in today, then that person is the designated agent of that individual.
Alternatively, it could just be the dog walker takes the animal to whatever veterinarian they want
Absolutely.
to, and the owner
Yes.
has no legal interest right now.
And then the tort there is the person who's misrepresented themselves as the client. That is a crime that person committed, which is civil in nature. That's them wronging the client. And it's a unique challenge in veterinary medicine because we're the only ones that have this unique VCPR. In human medicine, there's no C, right? So it's a very unique situation. We really have to think it out. We're the only ones that do this, that we're the only ones that are having this scenario and this situation. But in the real world, it is a lot trickier to try to figure it out.
Marie has a comment.
That happens all the time, but I still think while I would like more than what Jessica said, but even what you said, who identifies as the owner, when I lecture, I tell people, get the name of the owner. Don't just get, whoever brings the animal in, don't automatically fill out that client form with whoever, because you want to know who actually is responsible for this animal, and you need to start doing that because it's not just a civil thing. I deal with administrative things all the time that have to do with, who was responsible. Mm-hmm. Mother wants the dog euthanized, father wants to keep the dog alive, the kid is in the room crying. I get these all the time. So I think some clarification of owner is better than none, because just leaving it as owner is such a non-legal term that it just opens itself to everything. Whereas even if you tie it into that they, I don't remember your exact wording, but identifies as, that at least there'll be some effort made, and the vets can say to people, listen, I need to know who's identifying themselves as the owner here. Yeah. And I know it's tough.
I think it could become intensely problematic.
But I think we need something other than client equals owner. So
I think it should be more that the client should be defined by what they do, what their role is in establishing the VCPR. And I still think there's room to have a designated agent in there. And yes, if somebody misrepresents themselves as a client, that is a problem, but that isn't a problem that is going to be solved within the arm of administrative law. So I think there's a better opportunity for it, and I do think there is value to defining the client in the VCPR. I just don't know if calling them the owner is going to work in all cases.
Thank you. Marie?
Would it be too vague to define client as the person, persons, or organization with legal interest in the animal?
I'm not really sure what legal interest is, because, you could have contractual obligations and authority, and that's a legal interest in the animal. Like the trainer could have a legal interest in the animal just for, because they're employed to provide care on some level to the animal. I think it's a bit vague.
So, Dr. Miller, I've actually had a very similar situation in my career multiple times, I feel like, and it's challenging. And I always assumed that we had to have the owner make the decisions anyway. And I've been surprised when I've had this discrepancy in couples, or sometimes they share custody of an animal, but I in those situations we've had to you have to kind of just work through those in a way that, as you said, it's the person that's been bringing the animal to you. We have to try and get them to put the other person on the record, and it's a tricky thing. It's a tricky thing now. So even before it's been defined, I think it might actually help to have a definition, because then we might be more likely to get clear data from the people presenting the animals, as Bonnie suggested, what her recommendations are to her clients. So, and when she teaches. So, I agree. That's a good example of a sticky situation. But I feel like it will be almost impossible to legislate around every possible scenario.
So that's a great point, and thank you for bringing that up. So when you work through those individual scenarios, right now, the law is neither for or against you on those scenarios, which gives you the latitude to be able to work through those scenarios based on your understanding of the VCPR. If we change this definition now, you will take a civil matter between two people and extend a consequence in administrative law to veterinarians because you will be affirmatively saying that the client is now the owner.
But not if it's worded as the way that we're saying, because it would say the person that is representing themselves identifying as the owner, and that's the person that's presented you the animal and said, yes, I am the owner. And then if they say, well, I co-own this animal, then it would be like, well, we're going to have to get permission from both people. So this does protect, this actually is better because we can say, well, this person was representing as that, and I'm sorry, but that's how this.
That's a good point, but can we do that? So when we're all gone from here and somebody looks at this 10, 15 years down the road, I want to make sure that they understand it in the same way that we did. So in that scenario, can we alter that definition to indicate that at the time services are procured, the client is the person who represents himself as the owner or who identifies as the owner? Because what I'm concerned about is somebody coming in after the fact, as soon as they're deciding to get divorced, to say, well, no, I'm the owner. Well, you know, you're not the client per the definition, because at the time the animal was presented to me, it was presented by this other individual. So can we keep it in a real-time setting? So rather than at any time in the timeline somebody can come in and identify themselves as the owner, can we at least define it as at the time services are procured?
Or provided.
Provided, thank you. Is that possible?
So Dr. Sullivan asked me to type something up real fast. So this is what I have. Client is an individual in parens S for individuals who has represented to the veterinarian that they are the owner of the animal patient and has authorized the veterinarian to assume responsibility for medical judgments regarding the health of the animal at the time services are provided.
Do we need all the authorization stuff?
Well, I'll scratch
because
it.
that's
Can you
part of the
just read that one more time?
Okay, I'll take that part out, Tara. So I'll say client is the individual in parens S, individuals, who has represented to the veterinarian that they are the owner of the animal patient at the time services are provided.
I would just change client, the is to means, so that conforms, yeah.
So client means the individual, parens S, who has represented to the veterinarian that they are the owner of the animal patient at the time services are provided.
I see lots of nodding of the head. Let's move on.
No further comments.
Dr. Sequoia?
Yeah, I like it, except it's the individual. How about the individual or individuals? So if two people come in, or the one individual on the, on the new patient, new client writes down, I am the owner, and the co-owner is such and such. I think you need an individual or individuals.
Yes, it is the way, and I know you can't see it, the way Jessica wrote it is individual with the parentheses of the S
Okay, great.
to
Thank you.
have that, of course.
Wonderful.
And I believe that we have not yet opened up for online public comments on this.
Perhaps what we could do, is a motion to do it as amended and then open it up to everybody but the entire proposal.
I would love to make a motion. Let me come up here. So this is on the page 4, correct? Yep. Okay. A motion to recommend to the board submission of the legislative proposal as amended to the California State Legislature to amend sections 4825.1 of Article 2 and 4875.1 of Article 4, and add sections 4826.01, 4826.6, and 4829.1 to Article 2, Chapter 11, Division 2 of the Business and Professions Code.
Second.
Okay, we have a motion on the table and a second. Any comments from committee members? Right, comments from any of the public in the room? Except for nodding of heads, yay. Online comment from the public, if we can open that up, please, moderator.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. And then if we can call the vote.
All right. Mr. Phelps?
Yes.
Dr. Sullivan?
Yes.
Dr. Bradbury?
Yes.
Dr. Lazarchuk? Dr. Lazarchuk? You're muted if you're trying to vote. All right, I'm going to mark him as absent. Ms. Laredo?
Yes.
Dr. Sequoia? Dr. Sequoia?
Yes.
Okay, Ms. Esri?
Yes.
Motion carries.
Thank you very much.
We got there.
All right. So with concluding that, we've done 5. We will be moving on to agenda item 6, which is our update discussion and potential recommendations from our complaint audits process subcommittee. The words backwards in there, which would be Drs. Bradbury and Sequoia.
Dr. Sequoia, do you want me to go over this, or would you like to present any of it? Okay. I'm up. Okay. I just have to pull it up. Sorry, guys. Okay. All right. So I know you guys have all of the meeting materials. I'm going to just run through this. The meat of it is kind of at the bottom of the meeting materials, but just as some updates, we did a subject matter expert training, I guess it was a year ago now almost, and it was very well received and seemed to be really helpful. At least that's how the experts felt. We felt like it was a success. As we've been talking about things, we decided that it might be better to have a more regular meeting, and so we've decided to have quarterly meetings, and the dates are in your packet, but we feel like that will allow us to provide feedback kind of more directly and have in our first training or meeting, the experts had some questions, and it really felt like they wanted more support and kind of some more direct discussions about their questions rather than just kind of assuming things. And so we really just feel like this is going to be helpful in us understanding their issues, also them understanding the process better, having their questions answered, just helping making them better. So that's something that will be participating in as the subcommittee, and I think the staff will be putting on the most of the information that's provided. I'm going to just skip to the real-life examples for expert training. We've provided the example that we gave to our subject matter experts. It was one kind of general case, and there were 4 different scenarios surrounding that case, and we had them answer as to whether they thought it was a departure from care, an extreme departure, no departure, or a medical records issue. And we wanted to provide a case with different kind of nuances to it, so that they were starting to understand that they should be looking at very specific things. For example, related to the spectrum of care, and if they've offered testing and the client's declined, and there's a negative outcome, that's not a departure from care or departure from the standard of care. So anyway, we just wanted to provide some additional examples. It was provided in a SurveyMonkey, kind of a quiz format, and the experts were asked to provide comments afterwards. And overall, it was very well received. There were some questions, and so at our February meeting, we're going to go ahead and answer those questions for them and try and see if they had any other suggestions or concerns. This was a small animal example. I know that some of the thoughts from the experts, one expert was hoping for an equine example. And so we are going to try and make it a little bit more diverse moving forward. But the first one, I think, overall was a success. Coming back to case reviews, we've had a couple of cases to review. I think we're still kind of just now getting cases with experts that are currently still experts. A lot of the cases that have closed, the experts are no longer with us. But overall, things I think are improved from when I started on the committee, like markedly improved. I think that some of the direction and training is showing in their reports. And the one case where I did have questions and concerns, I actually spoke directly with the expert to get clarification and kind of to work through it. So we're really working hard to improve this part of the program, and just, not just expect them to know what should be done. And anyway, I feel like they're really coming along. So that's sort of it for the updates outside of these changes that we're looking to make. There's one more thing, which, as you all know, there's a lot of cases still pending, and that is of huge concern to everyone on the board. We would like to see those numbers come down. Jessica and I have talked in our meetings, both in the subcommittee meeting and in our executive board meetings, and it's just top of my mind, the number of cases and the length of time that these cases are taking. And, there's always the question of, is there a way to do this more efficiently with the staff that we have, with the process that we have? And one option we have was to participate in this Enlightened Enforcement project, which I think our licensing group went through as well. Last year? Was that last year or 2 years ago?
No, yeah. So it's DCA. It's our DCA director who started it, and we looked at one process, licensing processes for one board, and all of the subject matter experts within all the programs participated in that and provided feedback on it. So this would be similar, but on the enforcement side.
Yeah. But it's looking at the efficiencies of the program as well, correct?
Yes, we're looking at this one is going to be focusing on the enforcement processes of the dental board. So where we'll all learn from each other, and they might be doing something really, really well, or we can identify areas of improvement for them, but also anyone else who has enforcement. A lot of it is the same process because it's more dictated by the Administrative Procedures Act. So by having all of the subject matter experts from various boards for enforcement in on that, then we can all learn from each other of what works best.
Okay, and that's going to be going on throughout the year? Okay. And then I think we're also looking at some intern positions, and that is to help our analysts with some of the kind of paperwork and busy work that would then free them up to be able to work the cases. So I'm hoping that some of those things will improve the process even further. I know they're working really hard, but those are some additional programs and ideas that have come up and seem to be, that I think are going to be implemented this coming year to try and improve the caseload. The big thing, though, is we were tasked as a subcommittee to look at the expert witness criteria, and this has come up for several reasons, but we spent some time looking at what our criteria were, as well as what other healing arts boards' criteria were, and then we looked at what we already had, and then what was required on kind of the form that they would fill out if they were applying for it, and it was all over the place. So currently in statute, it's in front of you, in Business and Professions Code section 4875.3, there is a statement that says a veterinarian who reviews and investigates an alleged violation pursuant to section 4875.2 shall be licensed in or employed by the state either full-time or part-time and shall not have been out of practice for more than 4 years. So this was just sort of in there, but that whole statute is no longer even what it used to be. It isn't referring to something meaningful at this point, and it turns out that no other boards have such a statute. And I think Dr. Miller came up and talked about how this wasn't even supposed to be related to expert witnesses. In our on our website, when we look at the criteria that was listed, it had just 3 things. That was possessing a valid and current California license, 5 years of clinical practice experience within the 6 years immediately preceding application submission, and no past or current disciplinary action taken against the license in this or any other state. So they weren't the same, first of all, and second of all, the statute really doesn't seem to be serving a purpose, and we felt shouldn't be there, and it would be better instead to actually create a more robust expert criteria and place that into the administrative manual in order to, or the procedure manual, in order to allow for us to be able to change it a little bit more easily if we 10 years from now, the board says, oh, this is, not current, there's some other things we should add to it, or we should take this out, this isn't working, it would be easier for us to do that. So after a lot of discussion about and looking at these other healing arts boards, we came up with these requirements, which you have in front of you. We still think it's important that they possess a valid and current California veterinary license. Instead of, we wanted to be a little bit more specific and say at least 5 years clinical experience in the area of expertise. that they're saying they can be an expert in. No past or current enforcement or disciplinary actions taken against their California license. And that's specifically the California license because there's a possibility that they've had some disciplinary action in another state that is not something we would have considered as a disciplinary issue. We wouldn't have taken action, and when they applied for their California license, that would have already been addressed. So if they don't have any actions taken against their California license, then I think we're covered. The next one is practicing veterinary medicine. We put how that's defined for a minimum of 32 hours a month, so that they are currently practicing in the field. And then just some other statements to remind people that they need to recuse themselves if there's a conflict of interest. And there was a statement in one of the other healing arts boards that said that they must not represent their credentials, qualifications, experience, or background. We would assume they're not, but why not write it down? So this is what we have before you. I think that the idea is that we would like to add these to the administrative procedures manual and then remove the, we would amend the BPC code 4875.3 related to expert reviews. Yes.
So I received some edits from Tara this morning on the subject matter expert criteria, just making some minor changes. So I emailed it to Jeff. Jeff, can you jump to page 19, please, so we know what we're looking at? Okay. So you can see the majority of it were minor edits to the bullet points, but then the major part that was added was citing the Government Code Section 87-100 Common Law and BMP Code Section 450, adding that SMEs shall comply with all conflict of interest and confidentiality requirements discussed herein, and in the event of any perceived or actual conflict of interest shall recuse themselves from the case review.
And just for clarity, those sections of law on the left-hand side copied in there are just copied from the conflict of interest section on page 12. It's just a reminder that not just board members and MDC members, but subject matter experts also have to comply with the conflict of interest provisions as well as the confidentiality restrictions under the DCA incompatible work activities.
I'm fine with that. Okay, that's all I've got.
So going back to your memo, it looks like you're looking for 2 motions, which the language is provided. We just ask that if you are okay with the amendments that we put in today, then you would just say for the second motion, you would just do as amended. So the specific motions are on page 4 under action requested.
Or do we need to discuss first if since nobody's made a motion?
Want the motion first?
I don't know. Whatever you think.
First, and then a second, and then we
I
discuss.
move to recommend to the board the legislative proposal to amend Business Professions Code Section 4875.3 related to expert reviews.
I second that.
So that is for Part A. Do we want to make one motion for both, or they have to be separate?
They should be separate.
Okay, perfect. So then we will open up for discussion from the committee. The first motion, motion A on page 4. Any comments from the committee? public comment from those in the room?
First of all, I wanted to say in a public forum that your staff is amazing, Jessica, and we love working with them, and they are so responsive, and things have changed so much that we're very grateful. So thank you. Thank you. The only comment I have is that 32 hours a month seems a little bit skimpy to me. That's only 8 hours a week. I would like to see subject matter experts with a little more under their belt as far as cases that they've reviewed, and not sort of just dabbling in veterinary medicine and then jumping right into doing reviews. So I would suggest at least 40 hours a month and maybe even more. Thank you.
So before we discuss that, though, we're doing one motion for A, and then we'll do B.
That's okay. Go for Part B. So for Part A,
Go ahead.
any further comments from the room? Okay, then if we can, moderator, please open for public comment online. This motion for Part A.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. All right, and seeing no requests for public comment, would you like me to close that Q&A feature?
Yes,
I apologize. We do, sorry, got one in last minute. Request from Marcia Smith. And Marcia, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
For sticking it out through a long day. I have a couple of comments on this. The second point, 5 years clinical experience in the area of expertise. I think that may be difficult to define. Who defines the area of expertise? If it's a case, for example, a dog who
Dr.
presents.
Smith, Dr. Smith, I
Yes.
apologize to interrupt. So right now we're just on motion A, which is action A, which is specific to the ledge proposal. The enforcement criteria or the subject matter expert criteria we're going to add is not for public comment at this point.
Oh, I'm sorry. Okay, I'll wait. I'll come back later.
In that case, it appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Okay, then if we can call the vote on motion A.
Ms. Schafelt?
Yes.
Dr. Sullivan?
Yes.
Dr. Bradbury?
Yes.
Dr. Lazarchuk?
Yes.
Ms. Laredo?
Yes.
Dr. Sequoia?
Yes.
Ms. Usry?
Yes.
Motion carries.
Thank you. And it sounds like we do have more discussion ahead for the potential B motion. So I would like to ask if we could take a quick 10-minute break and come back to discuss that after that. That goes along with the thank you for your patience with the technical difficulties on the computer end here in the room. I think we've got it all straightened out now so that we will be able to move on to agenda item number 6. Now we would be looking at making a potential motion for Part B from page 4 of that agenda item. Anybody like to make a motion?
I move that we recommend to the board the proposal to amend the Administrative Procedures Manual relating to expert criteria.
I second. Sequoia seconds,
As amended.
as amended. I second as amended.
Thank you. Comments from the committee on this item? I know we had a few online. Anybody, public comments from those in the room?
I just had that one comment, so I don't know that I need to make it again. I just think 32 hours a month is a little slim. Thank you.
Hi, Grant Miller, CVMA. So just one comment for your consideration on the second bullet. The proposal is at least 5 years of clinical experience in the area of expertise. Would you consider altering that to say at least 5 years in the immediate preceding blank year 7, he is opining? So justification for the 7 years, I am amazed at how quickly practice changes and develops. I mean, just in equine medicine, just in the past few years, we've had this explosion of intra-articular new therapies, everything from autogenous therapies to polyacrylamides to genetically engineered collagen and elastin cross fibers. I mean, all these crazy things. And it seems like if you just turn your head for a minute, the practice becomes almost unrecognizable based on the technological advances. And so to say that the person has had 5 years of clinical experience, if that experience was 10 years ago, I would argue that that person really doesn't have the justification to opine on a case today. So I would like you to consider possibly making that a time-sensitive requirement. And then the comment on the phone was Dr. Smith had mentioned something about in the area of expertise. I would just try to alter it to say in the area on which they're opining. So if it's an equine case, it has to be equine experience, or if it's track, it has to be track experience. So for your consideration, thank you.
Thank you. Other comments from in the room? Okay, then moderator, if we can please open up the online comment.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And it looks like we do have a request for comment from Marcia Smith. And Marcia, please click the unmute me button when the prompt appears on your device. You'll be given 3 minutes to speak and a 15-second warning.
So just to introduce myself, I'm a currently licensed California veterinarian who retired last year after 39 years of practice. And my area of practice was small animal medicine, specifically internal medicine. I do have a concern regarding the second bullet, and although I agree somewhat with Grant's comments, I think leaving the phrase in the area of expertise then demands that somebody will have to decide whether the subject matter expert is an expert or not. And so to give an example, what if it is a case that involves a dog who has had an acute kidney injury and the complaint involves whether the care was appropriate or not, then does the subject matter expert have to be a small animal clinician, or perhaps a canine clinician, or perhaps a nephrology expert? So I think that the phrase leads to almost a requirement that somebody make the decision, and who is that somebody to be? So I actually think the phrase should be eliminated. I also have a concern about the fourth bullet, partly because I just have a general disagreement with unenforceable rules. So it's easy to tell if somebody's a California, currently licensed California veterinarian, whether they've had disciplinary actions, whether they've practiced for 5 years or 20, but not so easy to determine how many hours per week they practiced. Also, although I agree with Ms. Lutz that 32 hours a month may be inadequate for somebody to serve as a subject matter expert, particularly if they've only had 5 years of practice, I contend that a DVM with, say, 20 years of practice at over 160 hours a week will still be qualified to review cases for many years after quitting practice. And I would like to see that change to out of practice for no more than X number of years, say, rather than
15
practicing
seconds.
currently at some number of hours. Thank you.
Thank you, Dr. Smith.
All right, this is the moderator, and it appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
So thank you, everyone, for your comments. I think Bonnie has another comment. Yeah, that's what we're here to do. And thank you, Dr. Smith, for waiting through all of that to make your comments. I appreciate your participation and patience.
I know that the board knows this, and you all probably know this, but it's really not appropriate for a boarded specialist to be reviewing cases of a generalist, because I've run into that before, and it's very problematic because they do have a different standard of care. Thank you.
Well, I will say that we struggled with some of these for the very reasons that have been brought up here today. On one hand, we don't want to, we're struggling to get experts. That's our bottleneck at the moment. How many cases do we have waiting for 750?
Yeah, we have 748 cases against 421 respondents as of Friday, waiting for a subject matter expert review. I don't have the date of the oldest case. I don't have that information for you.
So we're trying to balance the ideal with our reality and what might be somewhere in the middle, so that we aren't eliminating people who would likely be good expert witnesses because they are semi-retired and working, 3 days out of the month. But we felt like it was important, particularly if, in their review of the case, but also, if it were to go to trial, we think it's important that they can represent the current state of practice. And so that's why we felt it was important to put currently practicing. So that's where that came from, that sort of balance in the hours. Similarly, the at least 5 years clinical experience in the area of expertise, I would like that to be more specific also. Dr. Miller, if you could convince anybody to be an equine, like any good veterinarian to be an equine expert, please. Like these are things that we're struggling with is, we want good experts. But if we make it too specific, I think we run the risk of having even less in our thing. So the nice thing, though, is that if it's in our procedures manual, as part of what I think we're trying to do is more and more outreach to veterinarians so that they maybe can understand better that their participation isn't, if as an expert witness, would not be an adversarial role as much as, looking objectively at cases. Maybe that will help with this, and as time goes on, we can, shore up these criteria, but I'm concerned about making them any more specific because of that. But I do, I'm open to everybody else's opinion on this. That's why we are doing this in the first place. So.
But if you're concerned that we're going to have a weakness in a court case, then I think Dr. Miller's comments are even more critical.
Yeah.
So.
And what was the wording of that again, Dr. Miller? I was trying to type it, but, failed to get it all down.
So my attempt is at least 5 years of clinical practice experience in the immediate preceding blank years. In the practice area on which the SME is opining. Does that make sense? Tara's way better at this than I am.
I would have a tweak. So have at least 5 years of clinical practice, practical experience immediately preceding the SME application. We need a set period of time that they have to meet this 5-year requirement.
But, thank you, but if you're allowing yourself more latitude by giving them 5 years within the previous 7. So they maybe for the last couple of years haven't done it, but I would contend that you can take a couple years and still be really pretty current with things. I think if you take 10 years, you have no idea what's going on in that practice area after 10 years. And that's just my opinion, but Tara, what do you think about that? Just rather than the immediate preceding 5, give them a window to say you have to have at least practiced in, I don't know, avian medicine during 5 years during the last 7, 8 years.
So you're saying have...
So you want it to be immediately preceding application. I'm saying in the last 10 years, have you at least done 5 years of avian practice?
Right, hold on. It would be have clinical practice experience in 5 of the past 7 years, right, immediately preceding the SME application.
Correct. And it may be longer. It may be a wider window.
Numbers, yeah.
Right. Right. And then, rather than expertise, I would be talking about what area of practice are you asking them to opine?
Yeah.
And then, as an aside comment on the 4th bullet regarding the 32 hours, with all due respect to the others in the room, this may be a 16-year-old telling you they're a good driver. I only practice 4 days a month, and I would feel very comfortable, I would feel very comfortable being an expert on a case, because, I do it. I'm 44 days a month, maybe 6 if I'm really busy, and I feel pretty current. I'm doing all my CE. When I talk to my fellow colleagues at the CE, I'm not feeling like I'm losing any information or that I'm not current on things, so I actually feel like the 32 hours reflects a pretty reasonable, I don't know, maybe I guess I'm biased, but I think it's fine.
Jeff, can I ask you to go to the 2nd bullet and type what Tara had written?
Thank you.
Okay, so it'll read in the 2nd bullet, have clinical practice experience in 5 of the past 7 years, immediately preceding the SME application. And I don't know if you want to add the end there, in the area of expertise in which the SME is opining.
And then there was a recommendation to change expertise to practice in the practice area.
Practice. I think type is probably, after Dr. Smith's comments, I think type type is probably more clear than area, because it's small animal, specialty, equine, avian, yeah. I think that's more clear.
I'm going to read the end again. After expertise right now, insert in which the SME is opining. And while you're in there, Jeff, in the third bullet.
Yeah.
Okay.
Yeah, did we talk about changing expertise to area of practice? Oh, area. Practice type.
In the practice type.
Area. Practice type, sorry, still in front of me.
In the practice type.
That was better.
Good. Probably don't need a second in practice type. Having clinical practice experience. And probably 7 years of sitting with the physician. You need a second in the practice type.
Does two practices have clinical practice experience for 5 of the past 7 years, immediately preceding the SME application in the practice type in which the SME is opining?
So can you put, have clinical, okay.
We can say have clinical experience, and take out practice if we feel like we're using that word too much. In the filer, we'll remove practice.
Yeah, we can do that. Take out the first practice.
Or you could move up, let's see, have clinical practice experience in which the SME is opining.
About have clinical experience.
It's the same as practice.
Inside of the, in the practice type, which is different than practice experience. And where?
The first practice out.
Oh, no, where, sorry, I was just saying that, don't type that. Sorry.
Seems to me if we just remove the first word practice, it would say not be repetitive. Yeah, I think so. Me.
Have clinical experience. Yep, there.
That's the same as clinical.
No, that would be the same word.
Right.
I like that.
So we had a motion and a second, and we talked about approving those amendments. Or further discussion?
The third bullet needs some tweaks.
3.
Line 2, after California, insert veterinarian. And then strike to practice veterinary medicine.
against the California veterinary license. Yeah, I think it's just as typed, but just the veterinary license would be the only thing changed.
So we already had the motion in the second, and we did amendments afterwards, so do you want to say as amended now? Can you come up to the mic? Sorry, we can't. Can you turn your microphone on? Thank you.
Specific instructions here. Dan Baxter with the CVMA. In the second bullet where it says have clinical experience in 5 of the past 7 years immediately preceding, I would suggest striking past because immediately preceding is saying the same thing. I think it's redundant to say past and then immediately preceding, but for what it's worth. Thanks.
No, I think if the people who made the motion and seconded agree with those amendments, the friendly amendments, I think we can.
I agree with the friendly. I agree with the friendly amendment or amendments.
Dr. Sequoia, we had you as down as the second. Do you agree with the amendment to the motion?
I agree with the friendly amendments. Or I accept the friendly amendments.
Okay. Do we have any members of the public who would like to comment on the amended motion? I see none in the room. Can we please, moderator, open for public comment online regarding this?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, seeing no requests for comment, would you like me to close the Q&A panel?
Yes, please. Okay, I think we are ready to call a vote. Do we need to reread the amended motion? Okay.
Ms. Felt?
Yes.
Dr. Sullivan?
Yes.
Dr. Bradbury?
Yes.
Dr. Lazachev?
Yes.
Ms. Laredo?
Yes.
Dr. Sequoia?
Yes.
Ms. Ostry?
Yes.
All right, motion carries.
Thank you. So the next agenda item 7 on the frequently asked questions are still being worked on the access to care portion. So I would like to skip to agenda number 8, which is the update, discussion, and recommendations for frequently asked questions regarding the VCPR. Dr. Sullivan.
During the July 2021 meeting, the board approved the frequently asked questions regarding the VCPR to address the increased questions board staff was receiving from the profession and consumers after April 1st, 2021, when the VCPR regulatory amendments became effective. This is a living document that will have to be updated from time to time. One such update was done in July 2022, meeting to address questions regarding the VCPR and vaccinations. Since then, the board has received additional questions regarding refilling prescriptions at alternate locations. So, question number 7. A corporation owns 2 veterinary premises and stores all electronic medical records on one shared electronic system. Dr. A establishes a VCPR with a client at premises A and prescribes medication for the animal patient. A month later, the client goes to premises B to refill the prescription from Dr. A. Can Dr. B refill this prescription without performing an examination, since Dr. B has access to the animal patient's electronic medical records? The answer to this question is each veterinary premises must be registered separately with the board. Although electronic medical record systems may be beneficial for a veterinarian at one veterinary premise to access animal patient records created by another veterinary premises, the VCPR follows the veterinarian, not the medical records. Do you want to discuss that or go on with the second part of that? Okay. In the absence of Dr. A, there are two exemptions from the VCPR requirement from Dr. B to prescribe, administer, or dispense medication. Number one, it's on an emergency basis to maintain the health of the patient until the client and patient can return to Dr. A. Or two, Dr. B works at the same veterinary premises as Dr. A, and among other things, in Dr. B's professional judgment, failure to fulfill the prescription might interrupt the animal patient's ongoing care and might have an adverse effect on the animal patient's well-being. This is related to section 2032.25 subsection B2 for a full list of the requirements. In the above scenario, if neither exemption applies to the situation, Dr. B cannot refill the prescription without establishing the VCPR. Do you want a motion before discussion? I move to recommend to the board the addition of new question 7 to the frequently asked questions regarding the VCPR, the veterinary client-patient relationship.
I'll second that.
Okay, motion and a second. Any comments from the committee? Dr. Bradbury.
I feel like because there's so many clinics that are sort of interconnected, now that there's going to be some additional questions like if the client comes to premise B and they are a sister hospital or, and the staff at premise B can contact Dr. A and they can write the prescription with Dr. A's name on it because they're employees of the same group. Is that okay?
Does he work at Clinic B also?
No.
Okay. My understanding is the VCPR goes with the doctor.
Okay, so he can't have them fill a prescription for him at a different hospital?
Another hospital can't fill a prescription for a doctor. That's pharmacy law.
Yeah, okay.
Okay.
I just figured this was going to come up, so.
Yeah. If he does some work there, I think that he could. But if he's not at that hospital, then the VCPR is not there. Right. Is that correct? Get a little nervous here.
Okay, any comments from anybody in the public in the room?
Just to clarify, I get this question all the time, and their theory that they tried to talk me into is that it's the same location because it's owned by the same people and the records are all together. So, I mean, I've already told them all that they're wrong, but we keep getting people calling me saying that their general counsel said it was okay, it's all the same. So that, as far as the ones that I submitted questions, that was their theory, was that because they were all owned by the same people and the records were all owned, that it was the same location. And it's not, I understand.
But they're separate premises.
Right, right. I know, I understand. But that was the theory. So I think we are going to hear more of that because the corporates they get together and they chat.
But we really have to be careful because when we started down this road, the pharmacy law says another clinic can't fill a prescription. So we've made some exemptions here along the way for emergency use. So that's kind of the law we're trying to follow.
Yeah, no, I understand, and I mean, I had told them that they were wrong, but that was why I submitted the question, and I continue to get those same questions. So.
Hopefully it's not from the same people. You don't succeed once, keep trying. Or get a different lawyer.
Can we please open the comments online to public comment on this motion?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. I'll go ahead and pause a moment to allow the public time to access these features and submit their requests. All right, and it appears there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Okay, motion on the floor. Can we call the question, please?
Ms. Phelps?
Yes.
Dr. Sullivan?
Yes.
Dr. Bradbury?
Yes.
Dr. Lazachev? Dr. Lazachev? Okay, I'm going to mark Dr. Lazachev as absent. Ms. Laredo?
Yes.
Dr. Sequoia?
Yes.
Ms. Usry?
Yes.
Motion carries.
Thank you. Next item on the agenda will be item number 9, update and discussion regarding requirements of Assembly Bill 1885, which is guidelines for cannabis use within the VCPR. Drs. Bradbury and Sullivan.
On September 18th, 2022, California Governor Gavin Newsom signed into law Assembly Bill AB 1885, and it became effective January 1st, 2023. This bill amends BPC Section 4883 and 4884 to prohibit the board from disciplining or denying, revoking, or suspending the license of a licensed veterinarian solely for discussing or recommending the use of cannabis on an animal for potential therapeutic effect or health supplementation purposes, absent negligence or incompetence. The bill required the board to adopt and post on its website guidelines for veterinarians to follow when recommending cannabis within the VCPR by January 1st, 2024. In addition, the Department of Cannabis Control is required to create regulations for animal product standards by July 1st, 2025. Upon review of AB 1885, the MDC Vice Chair identified minimal revisions that would need to be made to the board's current guidelines. Specifically, the background section requires updating. The term recommendations needs to be added throughout the document with corresponding revisions, and legal citations need to be updated. However, more substantive revisions may need to be made after the DCC's regulation are effective. Seeing as DCC's regulations would not be effective until July 1st, 2025, the executive officer at the vice chair's request contacted Assembly Member Coller's office to request extending the board's deadline to complete the new guidelines until after DCC's regulations take effect. And during a meeting on January 19th, 2022, Assembly Member, is that this year? No.
Sorry, 2023.
I'm sorry?
Sorry, it's 2023.
23, Assembly Member Coller's office requested the board make the minimal updates to the board's current discussion guidelines to make it clear that veterinarians can recommend cannabis to their clients for use on animal patients. Assembly Member Coller's office also asked the board to consider revising its guidelines again, if necessary, when DCC's regulations are effective. I did note that in the last paragraph of the last page of the phrase, so this would be under the paragraph of industrial hemp. That's on page 5. So the last paragraph of the last page of phrase says, quote, industrial hemp is not tested or regulated in the same manner as cannabis, so, unquote. That should be removed because AB 45, which was signed in October of 2021, does require CBD to be tested by state-accredited third-party laboratories for quality control, heavy metals, pesticide, et cetera, like cannabis. It's, yeah, down here.
Jeff, would you mind pulling it up so we can all be on the same page here?
It said right here, industrial hemp is not tested or regulated in the same manner as cannabis.
That's true. It's not regulated in the same way as cannabis because they're two separate,
But they are regulated similar to cannabis. They are now regulated because of AB 45 of of 2021, that they do have to be tested for heavy metals and pesticides and, you know, label quality of the label.
So are you saying that we don't need to warn veterinarians about recommending industrial hemp?
No, I'm just removing where it says industrial hemp is not tested or regulated in the same manner as cannabis, so, unquote.
Are you sure that it's regulated in the same way? The same way?
Well, as I read AB 45.
Well, AB 45 is about industrial hemp, right? That's not MCURSA, which has completely different requirements for testing for cannabis.
Right, so this sentence I'm saying, this part of the sentence is not correct. It is tested.
But it's not the same way as it is for cannabis.
Okay.
So we can change it, but I don't think striking it's real either. I think that we can say that industrial hemp is tested separately from how cannabis is tested.
Well, so, but leaving it in there, I mean, I don't think there's harm in taking it out because the rest of the sentence says, the veterinarian should use caution when administering, dispensing, or furnishing industrial hemp and ensure the product is used. I mean, we're still having a cautionary sentence there.
Sure, but it's still not the same. I mean, this is about veterinarians can now discuss and recommend cannabis. This is not about industrial hemp, and all of this is about is that industrial hemp is regulated in a totally different way.
So this is a paragraph in our guidelines that addresses industrial hemp.
Mm-hmm.
So what I'm saying is the part of that sentence I don't think needs to be there. We're still cautioning the veterinarian that
They should use caution.
I think, I hear what you're saying, Dr. Sullivan. I think some products are tested, but there's a lot of over-the-counter products now that say they are CBD and.
Okay, if it's industrial hemp for animals, and that's how it's labeled, it is tested. That's AB 45. That's new. I mean, new of 2020.
I guess I was under the impression that it was not. It still was kind
I
of.
have it here if we want to take a
fairly
look at it.
unregulated.
So is this going forward tomorrow?
No, because we didn't put it on the agenda because there wasn't any anticipated action, so it's not going to the board until July. I'm sorry, April.
All right, then I think maybe we should bring this back.
Well, to your point, Dr. Sullivan, if you strike that first part of the sentence, I mean, the point kind of becomes moot of whether or not it is. If the whole point of putting this in there is to provide caution, the sentence just reads, the veterinarian should use caution and continue on. So whether or not it's tested the same or not, it doesn't really matter. You're still cautioning them to do it.
Correct.
Right.
So what's the will of the committee?
I guess as I read it, I don't see that it adds much to it if we remove that. If it just started with the veterinarian should use caution when administering, dispensing this, and ensure it's industrial hemp and not cannabis. I think the end meaning is the same.
Do you have a problem, Tara?
I don't know. I mean, I'm trying to read AB 45 quickly.
It's pretty long.
Yeah, I know. I'm just saying, this is all about, providing information to veterinarians about the difference between cannabis and industrial hemp. And initially, we were saying, hey, by the way, industrial hemp is completely different than cannabis. These guidelines statutorily required are just about cannabis. So to the extent we're providing any cautions about industrial hemp, I want to be careful, again, about what we're striking from this based on, what we think AB 45 does. I don't know. I haven't delved into that. Specifically, I know that there are provisions under a different code section, or code, for industrial hemp than cannabis, but I was just reading, there's some kind of combining of inserting cannabis under a definition of industrial hemp. I don't know what that's about. So before we strike statements with respect to the differences between industrial hemp and cannabis, I think we could.
Why don't we just put this on hold?
Yeah.
And you and I can look at it a little bit more, Dr. Sullivan, and bring it back in April, since we can't have and we could put it on the agenda for the board, and then the timeline's the same.
That's fine with me.
Do we want to accept public comment now? Yes, if there's public comment on this. Sure. Thank you.
So regarding that section, this section of the current guidelines, the industrial hemp section, is the one that everyone's reading because CBD companies are marketing to veterinarians, telling them that it's not THC, so therefore it's legal, which is not correct. It's misbranded. And so the current guidelines, the ones that are out there in the world now, end with a veterinarian who manufactures, markets, or sells drugs not approved by the FDA is in violation of federal law. That's where they end now. This next sentence that is in contention, industrial hemp is not tested or regulated in the same manner, so a veterinarian should use caution. I think the board should use caution in putting that whole sentence in there because these drugs are misbranded by federal law, and therefore it's illegal for us to incorporate them into our practice. So for you to say that you should use caution suggests that there could be another possibility. It's not possible for us to be utilizing these drugs until they're FDA approved, unless I'm misunderstanding something. They're misbranded drugs. So why then are we adding a sentence saying you should use caution? We have it in the current guidelines that they're illegal, and that's where it stops.
Well, because they're out there and licensees are being asked all the time about their use.
But instead of saying you should not use them in your practice, which is what is insinuated when you say it's a violation of federal law, you're saying you should use caution when administering, which suggests that there's some possibility by which they can be used. But I don't see that possibility. That's not possible under MDUCA. They're not compounded. they're misbranded, right? Jessica, am I missing it?
Well, yeah, so I'm actually looking at the cannabis discussion guidelines on our website, and it's the very last paragraph. It does have industrial hemp is not tested or regulated in the same manner as cannabis. The veterinarian should use caution when administering, and it goes into that.
But I'm looking at them too.
On our website?
As far as I know, I mean, I just pulled them up. Maybe do you know where they are on the website?
Yep. So I just went onto our website and I searched for the cannabis guidelines.
Is it a downloadable file?
Yeah, I just did.
Okay, so that's what I just downloaded, and that's what I've been disseminating to people.
There's the link.
Yeah, I've been disseminating that to people.
Is this what it looks like?
But neither is marijuana. But we have a law passed now that we can recommend it.
The veterinary should use caution.
It's already out there, so.
Okay, so Jessica just showed me a different version, but it's the same version because it's just switched around. But the point is still the same. You're saying you should use caution, but then you're saying it's a violation of federal law, which it's because they are misbranded. I think that we should, if we're going to alter that statement, I think that we should be saying, by definition of federal law, these are misbranded drugs, which is a violation of federal law, and stop it there. Because saying you should use caution when administering them, that's not...
But Dr. Sullivan and I were just kind of side chatting here, and it's a violation of federal law to use cannabis.
I give up.
Most people.
Yeah, so.
I think it should be considered. I think that the entire thing should be considered.
I see your point, because it's, we're saying this is treatment, and we're saying it's illegal at the federal level, but
yes,
it's some way it's authorized under state level. It's treatment.
Yes, and recommendation is different than administering, dispensing, or incorporating it into your practice. So this statement is saying that when you administer, dispense, or furnish, which we hate that word, but furnish means provide, that's different than recommendation. So while I agree with you that the ice is thin relating to cannabis, I do not feel that there's a gray area here. I feel that these drugs are misbranded, and it doesn't mean they're bad. It just means they're not FDA approved. And so I think that there's an opportunity to reword or to change a definition or add a definition of misbranded and then indicate why these drugs are misbranded under federal law. And then there's no other, we have no mandate in this guideline to say anything else. Like, it's a courtesy that we're saying this in the first place, and I think it's important because so many people misunderstand what is CBD versus THC or cannabis. So I appreciate that it's there, but I think that the board is over-obligating itself in that statement of you should use caution.
So, in AB 45, Article 2, 111921, and I think it's page 91. An industrial hemp product shall not be distributed or sold in the state except in conformity with all applicable state law and regulations, including this chapter, and any regulations proclamated thereunder, and with documentation that includes both of the following. A certificate of analysis from an independent testing laboratory that confirms both of the following. One, the industrial hemp raw extract is in the final form, does not exceed THC concentrations of an amount determined allowable by the department in regulations, or the mass of the industrial hemp extract used in the final form product does not exceed THC concentration of 0.3%. Two, the industrial hemp product was tested by any hemp derivative identified on the product label and or in associated advertising in accordance with section 111926.2. B, the industrial hemp product was produced from industrial hemp grown in compliance with Division 24, blah, blah, blah. Requirements if the source is outside the state. Okay, I thought that it included other testing, but anyways, that's the section that relates to what I was referring to.
So is the will of the committee to table this to the next meeting?
Yes.
All right, great.
Okay, and then if we have tabled that, oh, I'm sorry, Dr. Sequoia, your hand was up?
No, if it's been tabled, I'll give my comments next time. Thanks.
Okay, thank you. Then, agenda item number 10 is our update on discussions for RVT education. We just have some verbal updates on that. Jennifer, did you want to go over that, or would you like me to?
You're on a roll. Take it away.
All right. So for the RVT Education Subcommittee update, since our last MDC meeting, we've had multiple meetings with board staff and stakeholders, conducted additional research regarding the history of the school approval requirements, and reviewed the board's various statutes and regulations regarding RVT programs. In November, we met with Santa Rosa Junior College's Vet Tech Program Coordinator, Dr. Femini. As members may recall, Dr. Femini has called in during public comment portions of our meetings, and in regards to our previous rulemaking package on RVT education, he had various concerns related to the requirements and transition periods. Once we updated him on our board's decision not to proceed with that rulemaking package as written, he did express his appreciation. The subcommittee provided a brief history of the existing program approval requirements and an overview of the subcommittee's role in researching whether all RVT programs should continue to be board approved. Dr. Femini shared the history of his program, who regulates them, and how they develop their curriculum. As Santa Rosa Junior College started their RVT program in 2009, before his time, and there's no indication that they ever sought board approval or knew of the requirement to be board approved. Their curriculum, however, does mirror the course requirements in the board's regulations. Dr. Femini will participate in additional discussions regarding our RVT program approvals. In addition, board staff also provided the subcommittee a demonstration via Teams of how they process alternate route applications, which included an overview of what they receive from the programs and what things look like in processing the applications. In the coming months, the subcommittee plans to hold interested parties stakeholder meetings to discuss the possibility of removing the board approval requirement and only maintaining the regulations specific to the course requirements. Jennifer, anything to add? I've read that all out.
No, that covered it. Thank you to the staff for the presentation, and thank you to Dr. Femini for participating in those meetings.
Yeah, I can say until we talked to Dr. Femini, I think it brought home some of the points that we were looking for, and we really do appreciate his reaching out and giving us input of more things to think about as well. Comments from anyone on the committee? Any public comments? Okay. Do we still have to open for online? Okay, any online public comments regarding this?
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it does look like we have a request for comment from Gary Richter. And Gary, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. And Gary, you'll want to click the unmute me button when the prompt appears on your device. I'm going to request to unmute one more time. All right, you are now unmuted.
Charlie. Hi. Hi. This is Gary Richter, and I know that you guys have already decided to table the entire discussion about cannabis, but I really just want to stress the fact that you guys have a product neutral nonprofit that is comprised of some of the best cannabis experts in animal health in the world at your disposal. And the Veterinary Cannabis Society would love to have this conversation to help clear the waters here. There's clearly a lot of misunderstanding and a lot of verbiage that needs to be straightened out. So I'm just want to say that please reach out to the Veterinary Cannabis Society. We are here as a resource for you so that we can get this right and help our profession and help patients and help pet owners. Thank you.
Thank you, Dr. Richter. Sorry that I failed to ask to open the cannabis for online comment.
This is the moderator. Our next individual who has requested public comment, Charles Lozau. And Charles, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
To the MDC, my name is Charles Lozo. I'm also calling on behalf of the Veterinary Cannabis Society, which Dr. Richter just spoke about. Obviously, when Dr. Sullivan started to discuss AB 45 and the last paragraph on the attachment number 1, page 5 regarding industrial hemp, things get very confusing. And I sat from 10 a.m. today to listen to the entire hearing for this section. And I'm very thankful for the committee to take the time to table this because we don't want changes on the fly. We need time for reflection. The VCS Advocacy Committee is comprised of the former chair of the MDC, Jeff Pollard, Jeff Powers, chairman of the AVMA Council of Biologic and Therapeutic Agents, Dr. Andy Fleming, the former president of the New York State Veterinary Medical Society, Dr. Richter, who spoke just now, myself, a lawyer of 30 years, admitted in California and New York, who's been involved in this space since 2215 was discussed in February of 2018 in front of Dr. Sullivan, and Bonnie Lutz, I believe, was there. So this is a very important area, and we have a lot of comments and suggestions. We saw this memorandum for one business day, which was yesterday because it was published on the 21st. I strongly support rescheduling this, giving us a window of time where we could submit written comments because this is a complex area as evidenced by the confusion. I don't believe, and I think VCS does not believe, that industrial hemp should even be mentioned here. The mandate of the legislation was 1885. We're here to help. We're going to submit a letter with a bibliography of current medical research to help the MDC get these guidelines in place. We have time because the legislative mandate requires them to be posted by January 1st, 2024. Thank you.
All right, this is the moderator. It appears that was our last request for public comment. Would you like me to close that Q&A panel?
Yes, thank you. So we don't have any action on that agenda item number, which will then bring us to item number 11, which is our future agenda items and meeting dates. Okay, so for our future agenda items, things that I have are our inspection subcommittee, complaint audit subcommittee, equine practice subcommittee, RVT education, our alternate premise subcommittee, and the shelter rulemaking are things for us for this year, correct? And then as far as future meeting dates, I have April 18th, July 18th, and October 17th as our upcoming committee meetings. Anybody, anything else? Any public comment on future meeting agenda items, dates? None here in the room. Anybody online? If we can open that up, please, moderator.
This is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. Okay. All right, business. Then we are adjourned. Thank you.